Hi, everyone.
Hi, Arabella.
Hello.
Hello.
Good evening. Good evening.
How are we? Not too bad. Kicking on in January. All right. Um, cool. So we'll kick off at 6 o'clock. Now, I'm not sure if people on the call and those listening have seen my message regarding assessment one. What I've done is there were still some assessment pieces which haven't been submitted yet. So I won't be able to take us through the group feedback session tonight, unfortunately, but we will absolutely have one in the next couple of weeks, well in advance of our assessment two piece. But I have released just your grade in Moodle on the dashboard, so you should be able to access that. And I've spoken to Nicola, and I should be able to release just your individual feedback tonight or tomorrow morning. So I'll try and do that tonight for people. I guess I will just say perhaps until we have the group session, if possible, maybe don't discuss it with one another just until we have all of the assessment pieces handed in, but I can release that to all of you. I will naturally be available for questions if you've got any questions about your mark or the feedback that I give you. I will try and cover off as much as possible in the group session so it all makes sense to people, but really happy to provide any other feedback that people would like. So just thank you for your patience again with all of that. With respect to week 8, well, actually the next few weeks, what I will say is we're entering into an area of succession law where I strongly encourage you to do a little bit of research and see what's available online, because estate administration, litigation, family provision applications, there is a lot of information available online. There's some really good diagrams or case studies or checklists that you might be able to find online. I will caution that by saying we are Queensland specific in this course, so just make sure that you are looking at our Succession Act and that you're comfortable with the law. But there are some really good resources out there. So if you haven't already, I do encourage you to jump online and have a little bit of a look, just to sort of further the reading and the lecture and the study guide. I think that will be of use to people. Before we jump into our questions, did anyone, or our workshop questions, did anyone have any questions about the material? Nope. It's very practical what we're covering off on now. And if you sort of have a good understanding of your base law that you're referring to, estate administration is quite a practical area of succession law. All right, well, let's jump into our questions. All right, so we're looking at the legal personal representatives, their duties, powers, and rights. So question 1, what is the difference between an executor and an administrator? Who wants to kick us off?
The executor can sort of go in straight away because they've been appointed, whereas the administrator has to wait to be appointed. So they don't have the immediate rights to sort of get started. That's at least one point to get started.
Yep, thanks, Emma. So an executor is appointed under a will, and so their power is derived from that will. And then we've got an administrator that needs to apply to the Supreme Court to be appointed in that role. Any other? Ella, yep.
Oh, sorry. I was just going to say that an administrator is appointed when the letters of administration has been granted by the court. So you need to apply for letters of administration to the court for an administrator. and they do have the same powers.
Yep, that's right. So essentially an executor and an administrator, they have the same role, but how they derive their power is the key difference. So that's something to really remember with these roles. I think it's in the notes too, but collectively they're referred to as your legal personal representative or personal representative. So if in your readings reference is made to a personal representative, we're talking about it executors and administrators. Any other thoughts or comments? No? All right. What about the key duties of a legal personal representative? Do they differ for an administrator? And where are a legal personal representative's powers derived from?
The powers come from Section 52 of the Act. The duties are to collect and get in the real and personal real and personal estate and administer according to the law.
Yep.
They have the duty to exhibit an oath, full inventory of the estate and render an account of the administration. Duty to deliver up the grant to the court, and duty to distribute the estate as soon as may be and pay legacy interest if applicable.
Yep, excellent. So Section 52 is our key section for the duties of your legal personal representative. Now, remember too that a legal personal representative is going to have the powers conferred on them by the Trusts Act as well. So that's Part 4 of the Trusts Act, and that's Section 49(1) of our Succession Act, which gives those powers. So this is because quite often, I don't think this is a later question, I don't think I'm jumping ahead of myself. Often you'll see in wills, a will maker has appointed an executor, and that same person is often a trustee as well. And an executor's role usually finishes, and then the trustee's role commences. In reality, there's often some overlap between these two roles. And as you'll see from the last exercise as well, our assessment, the person that's appointed as the executor is usually appointed as the trustee as well, except in the case, for example, if you're creating a testamentary discretionary trust in the will, you may actually appoint a separate trustee. However, the executor will most likely be the trustee for the residuary estate and for holding the residuary estate on trust before it is transferred to your testamentary discretionary trusts. So it's a very important role, and the duties and the powers do overlap. So just something to keep in mind. And as I said, that's Part 4 of the Trusts Act. Now, what about your administrators? Section 50, another key section of the Succession Act, which says that the administrators are going to have the same rights and be accountable in the same way as an executor. So again, just confirming your executors and your administrators, very, very similar role. Any other comments on your duties? Questions?
So basically the duties both come under Section 52 of the Succession Act. It's just how they're appointed that's the difference, but their duties are pretty much what's under Section 52. They're the same. Everything else goes the same then.
For executors and administrators?
Yeah,
yes.
It's just how they get their power that's
yes.
different. Yeah.
Yes. And there is some difference too around, and Emma, I'm not sure if this was you or Ella, but when property vests as well in those roles. But in terms of duties, Section 52 is your key reference point. All right, Looking then at some practical steps. Now, I think this refers to breaking away into smaller groups, but there's only 14 of us, so are we happy to remain together? Yep, seeing some nods. Cool. So consider some of the practical steps that a legal personal representative may need to take when administering a deceased person's estate to ensure that their duties are fulfilled. Further consider how you'd approach the administration of the estate. What steps would you take? Okay, so we've got our key duties: collect assets, exhibit on oath and inventory, deliver the grant, distribute ASAP, and pay legacy. So in terms of collecting in assets, what practical steps, if you've just been told, surprise, you're the executor of a will, we need to administer this estate, what are some of the steps that you're going to take?
Arrange a funeral and funeral expenses.
Yep.
Probably
One
go
of-
through all the personal documents of the testator to accurately determine what personal effects, what bank accounts, any other assets that weren't maybe mentioned in the estate, which would go into intestacy then, possibly.
Yep.
Yeah.
So one of the key things is if your duty is to call in the assets of the estate, you actually need to know what assets we're dealing with and what needs to be called in. So as Bill said, looking through the person's personal papers and documents and finding out, okay, what are the assets? Who do we need to contact? Most people will have bank accounts, so bank statements, life insurance, superannuation. People sometimes have hard copy certificates of title. So really looking through all of their documents is a really good first step to ascertain what's in the estate, so that you'll know what to call in. Cool. What else might we do?
Also like ensuring that we're notifying like banks or you know, specific services that have been engaged by the deceased, just notifying them of the passing and have them direct further information to the personal representative, or, you know, if the personal representative has engaged a solicitor, have it sent to the solicitor's address. Making sure, you know, items in the will are in the possession of the personal representative and that they're kept in a safe place.
Yeah, great. So you'd have a look through your will, particularly if there's gifts of chattels, for example, or shares. You're going to need to make sure that you know where those chattels are, and that you can identify your assets. Going through this process also aids with your ability, if required, to exhibit an inventory to the court, because it really is a matter of displaying these are the assets, these are the liabilities, these are the debts that I've incurred, so the court can really clearly see what was in the estate. So all of this groundwork and investigative work aids your ability to call in the assets and to prepare an inventory. What you might often do in practice, I'm sure some of you on the call do this already, a lot of lawyers will actually keep a running inventory of the assets called in, what the firm's handling, what the client's handling, throughout the course of an estate administration matter, so that as a starting point, that document can be provided to the court, to the client at the end of the matter, as a reference tool. So if they ever need to exhibit formally the estate inventory, they've got that document. And look, while most clients would engage a solicitor to assist with this process, it is really important to maintain this information whilst it's still fresh and whilst you're going through the process, because I don't know about all of you, but if I'm asked what I did 2 years ago on a particular file or in a particular matter, I don't remember So it's much easier to keep a record as you're going. What else might we do to help with our duties as an executor?
Get in touch and keep in contact with family members, spouses, partners, relatives in relation to the testator's personal effects, personal assets, anything that's at their property that may not be on inventory, that may not be on the will or mentioned.
Yep. And Bill, why is that important?
Because it could lead to an intestacy if it's not mentioned. It gets overlooked. An asset will get overlooked and then it'll fall into intestacy, and then you'll have all sorts of problems.
Yep. It's also really important as well, particularly if those family members are beneficiaries under the will, to make sure that you do establish contact fairly early on in the piece. Also, as Bill touched on, if third parties, family members, if they are perhaps living in an asset or they have some degree of control over information or assets that you need to call in, it's much easier to be on the front foot with people, so that you know exactly where the assets are. If they are beneficiaries, it's also going to help us with our duty to distribute as soon as possible, because it's much easier when you've identified your beneficiary is the correct beneficiary, and that as the executor, you've satisfied yourself that this is the appropriate person to receive the benefit from the estate. So with respect to beneficiaries, most executors like obtaining some form of acknowledgement, perhaps by way of statutory declaration, that the person is who they say they are, and also that they're not bankrupt and that their interest in the estate hasn't been assigned to a third party. Basically, so the executor is comfortable paying or transferring the interest to that beneficiary. Ella, have you got a question? Ella, I'm having some issues. I think Ella, we can't hear you, I'm afraid. Sorry, Ella, you're a little bit sketchy. So maybe pop your question in the chat and I'll come back to that.
I was going to say too, Arabella,
yes.
Sometimes I like to move quickly.
Sorry, guys. I think we've just got a little bit of All right, Emma, I think we're good. Sorry, back to you.
Yeah, so sometimes it's good to move the asset quickly to the beneficiary, particularly if they're incurring costs or running costs, so that it doesn't become part of the estate for maintenance. I did read about that, like the liabilities, because a lot of wills actually have it becomes the person who's the beneficiary to take over any existing costs and stuff. So the quicker they can be determined, the better, probably.
Yeah, no, absolutely. That's a very good point. What an executor has to be careful of is obviously, and we haven't covered this yet, but your family provision applications, making sure that they're not distributing too early. In the case, though, of chattels, so let's say, mum's jewelry, I know that there can be fights over jewelry, but just for argument's sake, jewelry, artwork, gifts, absolutely. It's really good to distribute those gifts as soon as possible. If though perhaps we're gifting a property or a share portfolio and there is a risk of challenge, we do just need to keep specific timeframes in mind. But as a general concept, absolutely. If the asset's incurring debt that the beneficiary is responsible for, they're going to want that asset as soon as possible. So absolutely, really good point. What else might we do?
Particularly if like there is no like local family or anything, you have to make sure that the property is secure. So, you know, if there's
Yes.
house, you need to like make sure that it's insured and that it's maintained, like particularly, yeah, if there is no one else living in the house. I was reading things about even like pets, like if there's anything there that, you know, the person has passed away and they would be responsible for, you sort of have to make sure that that stuff is looked after. So just like little things like, yeah, organizing like a mower person to go around, like just like, I guess in that immediacy of like before you even start figuring out distribution, actually just figuring out like what do we need to secure before like time passes.
Yeah, absolutely. And look, that can be one of the most difficult and time-consuming jobs if the will maker didn't have family, or if family is spread perhaps all over Australia, all over the world, and there's no one on the ground, so to speak, to undertake these small but very difficult tasks if you don't have feet on the ground. So simple things like looking at pets. Pets is a big one. You must insure property, so particularly real property houses. You're in a very precarious position as an executor if you haven't properly insured a property, because most policies will actually be voided on the death of the will maker. And if something happens to that property and it's not insured, your personal representatives, your executor, may be liable for any claims. So it's really important. I can't stress that enough. Similarly with motor vehicles, if you've got any assets of particularly high value, jewelry, artwork, those sorts of things, make sure that they are insured. More simple things, redirecting mail, that can be, if you're an executor, you can usually do that. Funeral, I think, Luke, you touched on that. That's really important too, maintaining the yard. Electricity, all your utilities, they need to be considered as well. So there are a number of small things that you need to do as an executor and as an administrator. Usually they relate to your duties to call in assets and to distribute on time, because you don't want to leave an asset, or a house, let's say, uninsured. Your utilities may be overdue, that the property may be in a particularly poor state, then needing to distribute, usually after 6 months, and there's a lot of work to be done. Julie, you've got your hand up.
Yeah, it's probably a question, and I'm sure you've experienced this, where you've got some family or relations that would go in and just pretty much take whatever they want prior to you being able to do all this. So is there anything that you can do to guard against that, other than the normal insurance and do your best to secure the property and so on?
From a practical perspective, and again, depends on circumstances, but you can change locks if you are very concerned that helpful family members will take documents. I think Ella might have touched on just notifying banks, for example, of the person's passing as soon as possible, because usually that then allows the bank to freeze the account, in essence. So even if the family members do obtain details, they won't really be able to access the accounts if there is concern around misuse of funds. But it can be, in reality, just extremely difficult to stop family members, if they've got keys, just going into the house. Depending on timeframes, I do sometimes recommend, particularly if the executor is perhaps a friend or a professional that's been appointed, to attend the property and take photos, you know, of the belongings, if there's an office, take photos of the documents, just so that you do have a reference for yourself. And it can also protect you if family members then say, oh, you took so-and-so and you took the rings, and all that sort of hoo-ha that can happen. But the reality is, Julie, it can be really difficult. And in a lot of cases, you can't stop that from happening, and you have a fight about, what did you take? Please give it back. That is often sort of overcome if a grant is obtained, and the executor can then deal with your asset holders. But with chattels, it's really, really difficult. Yeah.
Sorry, Arabella, can you hear me now?
I can at the moment, Ella. Yeah.
Okay. All right. If it cuts out, just let me know. I was going to say an important thing as well is if you've got someone like living in the property, we've got a matter at the moment where our executor is living in the property of the deceased, and they're having to maintain the property. So like, you know, they had to get some trees cut down and stuff like that, or, you know, someone broke into the house and the police recommended security cameras. So security cameras were installed. And I guess it comes back to the fact that she's also probably racking up the bills because she lives in the house, but also maintaining the property, making sure it's kept in an orderly fashion for when
Ellie, you've just gone on mute, but you're making a very good point. If someone is living in the property, we do need to make sure, well, firstly, that they're notified. If they're the executor, they probably know. But if someone is living in the property, they need to be notified that the deceased has passed away. And there does need to be, I guess, a discussion around what is going to happen to that asset, whether it's to be sold. And having these conversations early on in the matter generally makes it much easier to deal with. You will also find out much sooner whether or not there's going to be a dispute, which, again, ensuring that you are distributing to your beneficiaries as soon as possible, it is really important to ascertain whether or not there will be disputes. Talitha?
Sorry. Just on that, if someone's living in the house who's not a beneficiary of, like, who isn't going to get the house, is it sort of just like a case by case basis in terms of like, how long do you give that person to move out? Like, you know, presuming they were living there, like with the consent of the deceased, whether, you know, it was an investment property or, you know, a friend living, like, you know, I would presume, like, if things are all like relatively happy, it would be just that communication. But I can also imagine that there's a lot of times where like beneficiaries run hot and it's, you know, there's a lot of conflicting feeling and tension. Like, is there any like guidelines or statute that sort of dictates when that person has to be like packed up and out, presuming they don't have, you know, a lease and a, you know, a valid tenancy?
Right. Yeah, that would be your first port of call. Is there a formal arrangement in place? Ideally, this would have been dealt with in the will drafting stage. You know, if it's a right of occupation, you might give that, you know, if the person's been living there for a number of years, they're a friend, or they're a family member, you might actually deal with that in the will, and that's where you can stipulate, you know, I give them 60 days. Otherwise, it really is about having that conversation, but the executor does need to adopt a reasonable approach. Ultimately, though, the duties come first. So if this is an asset that does need to be sold, let's say there's a mortgage, the property needs to be sold to pay this mortgage and perhaps other debts, the person does need to leave the property. I'd probably be looking at, I'm usually guided by like the Residential Tenancies Authority around the notices and the sort of guidelines and the appropriate sort of correspondence to provide the person with, because arguably it could be sort of a week about tenancy. So that's what I use to guide me if people aren't sort of open to general discussions. But as much as possible, having a discussion early on and saying, look, this property doesn't need to be sold. We'll give you 60 days to vacate. As long as you're clear and you're reasonable, if the tenant doesn't leave, that's when you sort of can take some more substantive action to have them kicked out if necessary. And that would be through a QCAT process, most likely. Yeah.
Arabella, here's one that I pulled out of the book.
Yep.
That is ensuring that money held in bank accounts is accruing interest at a reasonable rate
Yes.
for the benefit of residuary beneficiaries.
Yep, absolutely. So your legal personal representative, you really you generally need to act in the best interest of the residuary beneficiaries named in the will or pursuant to the intestacy provisions. So let's say there's $50,000 sitting in a bank account, but there's some complex property issues that need to be dealt with before the estate can be administered. The grant of probate is obtained, the funds are called into the estate. As Bill said, it's advisable that that money is then invested so that it's earning interest while the complex property matters are being dealt with, so that when it's time to distribute, the funds haven't just been sitting idle. They've been accruing that interest that can then be passed on to your beneficiaries. So absolutely, that's really important. Any other thoughts? Sorry, I'm just mindful of time. Any other steps that you might need to undertake? Sorry, Bill. Yep.
Yeah, apologies for that. I had a few issues with the internet as well. Wouldn't you ascertain well, I think it's probably been mentioned about the liabilities, any legal action against the estate or the testator?
Yep. Yeah. So that's really important, and it's something that arguably will come to light fairly quickly, particularly if there's litigation on foot already. Jumping ahead a little bit, with respect to creditors, when you apply for a grant of probate, you give notice ultimately to creditors that you intend to bring the application and for them to notify you of any claims that they have on the estate. Similarly, when you distribute, when you've reached that point, so sort of jumping from one end to the other, again, you can advertise your intention to distribute, and that protects your legal personal representative from any claims that are brought outside of these periods. But yes, we will absolutely need to know if the deceased was involved in litigation or if there's any claims that they themselves should be bringing. So just sort of on a practical level, a lot of where I work, we have a dust diseases team. So quite often, perhaps the will maker will have commenced proceedings seeking damages because they've worked with asbestos. They've developed mesothelioma, and they're seeking compensation for that. Very sadly, these people will die, and they often die throughout the course of the legal proceedings regarding the claim for damages. So in that case, the executor will be the appropriate person, or your legal personal representative, sorry, will be the appropriate person to continue on with that compensation claim. So that's sort of quite common in my little world, where the legal personal representative will be pursuing litigation potentially.
Yeah, I got the girl across the road that works in dust diseases.
Oh, okay.
Morris Blackburn.
Yeah, yeah. Any other thoughts of steps that we may need to take? Any other sort of practical steps that we may need to take throughout the administration? We've covered off on some really good key aspects. Might seem a bit obvious, but we may need to obtain a grant. If there's a will, we'll absolutely need to obtain a grant if there's no will. So that's something that the executor may need to consider. The other thing too, which is really quite important, is ensuring that sort of as part of paying the debts and ensuring that there's no debts of the estate or the deceased person, is ensuring that your taxation, both for the individual and for the estate, is finalised. As lawyers, we don't touch that. We always get an accountant to advise on that, but that's also something that is really essential to ensuring that the deceased's affairs are finalised and we can arrive at a place where the estate is ready to be distributed. So similar to paying all the other debts, we need to make sure that tax is finalised. Any other thoughts? Any other steps?
Yes. Oh, I was just going to ask, in terms of the obligation to, is it something like you need to sort of like, I guess, deal with any potential family provision claims as like quickly as possible? To fulfill that obligation? Is it simply like running running an ad, like advertising like the intention so that people could come out of the woodwork, or do you have more of like a positive like duty to actually approach people who you think potentially might bring something and ask if they're planning to? Like, how far, I guess, does that obligation go?
So I would take it back to your obligation to distribute as soon as may be, and to simply be aware that a potential applicant has 6 months from the date of death to provide notice. Remember to, and sorry, we touch on this a little bit later, but your executor or your legal personal representative will be protected from any, they'll have protection under the Succession Act for any claims brought, provided they wait the 6 months. So they cannot distribute 6 months from death. If they don't do that, they're not protected. It's very risky. So if you've got people that you think are going to bring a claim, I would not be contacting them necessarily. Depends on your circumstances, but generally no. I would just be making sure that everything you can do to prepare this estate for distribution the day after your 6 months, that you take those steps so that your 6-month period passes and you can distribute. Because if a claim is then brought, but you've already distributed, that applicant is going to be very stupid to pursue it. So you don't have a positive duty to reach out to people and say, oh, hey, you're an applicant. Are you going to bring a claim? I want to know. Rather, you have a duty to prepare the estate as quickly as possible, knowing the risks, so that you can distribute as soon as can be. I think Ella popped in. Where's it gone? The chat, you'll notice in the Queensland Law Reporter, that's absolutely right. So again, when you're applying for a grant of probate or letters of administration, you actually advertise your intention to apply. So again, that's advertising that you're administering the estate, the person has died, this is going to happen. And that is satisfactory. You're complying with your duties. So it's really on the applicant to be proactive. It's always going to depend on your facts. But if there's a risk, you just want to make sure that as much as possible, your administration is ticking over, you're applying for your grant, you've identified your beneficiaries, everything is, you've got your ducks in a row, so to speak. Yeah. Any other questions? But remember to, just going back to, dealing with family provision claims, the legal personal representative again, has to act in your best interests of your residuary beneficiaries, and they have the power to compromise a claim. So if it looks as though, or if notice is given, but it can be dealt with relatively quickly, perhaps by a monetary, settlement amount, something like that, the legal personal representative has the authority to make that call. And as much as possible, they should be trying to resolve these claims as quickly as possible, having regards to the rights and the interests of the residuary beneficiaries. That's really important. That's why, just jumping around a little bit, when you're drafting your wills, if there is going to be conflict or potential conflict, potential claims being brought, often it is advisable in the circumstances to have perhaps a professional executor or a third party, because, if you've got two warring siblings, one's the executor, one's not, that can add fuel to the fire. But getting ahead of myself, we'll look at family provision applications later on. Sorry, Emma, yep.
Yeah, I was just going to say, so what would be an example of something where the executor would have the authority to actually deal with something really quickly if it was just a payment or something? Like, what would be an example of something that's considered within that realm of being okay to do? Because that could be very broadly interpreted.
Look, I would say if you've got an adult child that's been excluded from a will, that's in extremely poor circumstances, clearly needs provision. They give their notice within the 6 months. The estate's moderate, we're not talking about a tiny estate. If they're seeking something like a gift of $30,000 or $40,000 because they want to buy a new car and, I don't know, go on a holiday, something like that, that would be very reasonable to settle a claim. Again, jumping ahead a little bit, but if the executor is wanting to deal with a family provision claim or even a debt, perhaps, they can seek the consent of the beneficiaries. So they can say, look, this is the issue. This is what I propose. We've got an adult child that's in, dire financial circumstances. There's a clear need for provision. I've got legal advice. We think they should settle. I'm suggesting 40 grand. The beneficiaries can say, yep, happy with that. Deal with it. Then it's dealt with before your 6-month period, arguably, let's say. And then you can just proceed as normal. The executor does have the ultimate decision-making power, though. Even if the beneficiaries don't necessarily agree, they can still enter into those negotiations and reach that settlement. So it really does just depend on circumstances, but usually where they're settled early, it's because there's, in the context of a family provision claim, it's really clear that this claim is going to get up, really. Yeah. Does that answer your question? Yeah. Cool.
Yep.
Great. All right. So look, in terms of practical things, just to cover off, we're going to be looking at personal papers. We're going to be contacting asset holders, getting information, talking to family members, securing the property, making sure it's insured, speaking to anyone living in the property, making sure that we're looking after taxes, debts are paid, grant of probate or letters of administration is applied for, making sure we've got the beneficiary's details. We're waiting our 6 months so that we're protected under the statute as an executor or administrator. And then we're going to distribute, making sure that we keep a record of what we've done so that if we need to, it can be exhibited to the court. And that's in relation to your assets and also in relation to debts that you pay or the estate's debts that are paid, debts that you incur as a legal personal representative and that you pay, and the actual distributions to your beneficiaries. Probably on this point, this is where I'd strongly suggest have a look online. There's some really good resources out there that have a really good overview of the really practical things that a legal personal representative needs to do. All right, question 4. How are liabilities incurred by a legal personal representative treated compared to liabilities incurred by the deceased person?
Aren't the liabilities broken down into 2 categories? These are the intrinsic liabilities of the deceased estate upon the death of the testator, and the liabilities incurred by the legal personal representative in their obligations and duties to their office and through losses and deficiencies in the performance of managing their estate.
Yep.
So the liabilities incurred by the testator before and upon the death are met exclusively by the deceased's estate. And if the assets are insufficient to meet these liabilities, the estate will be administered in bankruptcy.
Yep.
The liabilities which are incurred personally by representatives are the personal responsibility and liability of the representatives. However, they do have a right to be indemnified out of the assets of the estate for all liabilities properly incurred.
Yes. Excellent, Bill. Perfect. So I think the key word there is properly. Costs incurred by the legal personal representative must be reasonable and incurred truly in relation to the administration of the estate. So usually if the legal personal representative has engaged a solicitor or an accountant to assist them with the process, you're not going to end up in any murky waters. Things will be fairly clear cut. Possibly if a legal personal representative, is undertaking the task themselves, it may not be as clear to them what's reasonable, and they may take a few liberties, shall we say. So something just to keep in mind when clients come to you to discuss this. There seems to be just this general assumption that everything just gets paid from the estate, just everything. Not the case, and courts are really cracking down on this in the context of administration, but also in the context of challenges to the estate. So making sure that they're properly incurred and that they're reasonable. Any questions around debts? I think the textbook does go into it in quite a bit of detail, so it's quite good, but that's really important.
But basically, if it's reasonable, the executor gets reimbursed first before it goes to the beneficiaries. Basically, if it's reasonable. Yeah.
That's right, because you've got your order of payment, section 59, provided your estate's solvent, obviously. And look, your expenses as an executor, your funeral expenses, they're always preferred. So usually any debts that the executor does incur, they can be fairly confident that they're not going to go through this process and then be out of pocket. Yeah. Great. All right. Sorry, guys. I know we're taking a little bit longer. But question 5. Okay, so a common complaint, and this is absolutely a common complaint by beneficiaries, is that things are taking too long and that the legal personal representative isn't doing anything. Can a beneficiary take action and appoint a new legal personal representative if they aren't happy? I will say this is a very common question that I get from beneficiaries in practice. Everything takes too long and nothing's happening. So what do we think?
There's got to be some pretty significant reason for them to evict the executor, because, you know, they've got to wait the 6 months anyway. It'd have to be total negligence, like they've done absolutely nothing, like nothing's been progressed. You know, they've just sat there and let everything tick away and things have gone to you know, the detriment of the estate. It'd have to be proven.
Yeah, so it generally needs to be a fairly significant delay or a fairly significant breach of a legal personal representative's duties or powers. So we've got section 52 sub 2, which deals with a breach of the duties, and there's the capacity to seek damages for a beneficiary to seek damages. What I will say is it is very difficult to remove an executor. As Emma said, you need to wait 6 months minimum, and you're absolutely entitled as a legal personal representative to do that. And there is the concept of an executor's year. And the case escapes me. I can't remember if it's in the notes or not, but there's a principle at common law that a legal personal representative will have 12 months, and that 12 months is an appropriate time for administration to take place, subject to the complexities, the size of the estate, and sort of any other issues that or circumstances that are unique to that estate. So quite often a beneficiary will think nothing is happening, but they may not understand that you've needed to obtain a grant, send it to a bank, the bank has lost your paperwork, you've recompleted it, they've lost it again. They've now asked for something different. They won't accept your trust account details because they need a letterhead or a letter from you on letterhead confirming your trust account details, and all of that can take a very long time. So in that sort of circumstance, there really is no action. However, as Emma said, if you've got someone, an executor, or I've had a matter where an executor lived in the house, appointed as executor under the will, lived in the house, only asset of the estate, didn't do anything for 7 years, brother, who was an equal residuary beneficiary, really wanted his share of the estate. So that was sufficient enough to seek orders of the court, basically directing or ordering the executor to take some steps. Again, though, you need to make sure as the legal personal representative, as the person, or as the beneficiary, I should say, that you have acted appropriately and given the LPR sort of as much opportunity as possible, particularly if they are self-represented, to sort of right their wrongs, so to speak, and to commence some form of administration. Simply being slack isn't always enough. It needs to be, I guess, damaging to that beneficiary's interest. So it needs to be big. They can't just be slack. And usually in terms of, time frames, we do have that 12-month acceptable period. I will find that reference for you if it's not in the reading, so I'll make a note of that. Any other thoughts in relation to beneficiaries or shared experiences? Oh, Ella. Yes, exactly right. So Ella's popped in the chat that a personal rep can be removed, but the court are reluctant to do so as they don't want to interfere with the deceased wishes. Yeah, absolutely right. So again, the court likes to ensure that the legal personal representative has been given every opportunity to act appropriately and to fulfill their obligations within that role. Yes, Julie, it is. I'll find that reference and pop it in the announcements. Excellent. All right, just quickly, I know that it's not in the questions, but just remember that an executor or a legal personal representative can seek executors' commission, so Section 68 of the Succession Act. So that is one of their rights at law. And that can either be as agreed between the LPR and the beneficiary, so a sum can be agreed on, or it can be an application made to the court. As I'm sure you can all probably appreciate, it's much cheaper and much simpler if a sum can be agreed on by the beneficiaries and the LPR. But if necessary, the application to the court can be made. So that's available for both your executors and your administrators. Great. All right.
What kind of amount are we talking about here with regards to commission?
Look, there's some general formulas as to how to calculate your executor's commission. So off the top of my head, I think it's between about 0.5 and 2.5% of the net estate, and 3 to 5% on any interest that's been earned on the assets of the estate. Sorry, just reading the chat. 3 to 8%. Yeah. So they're guides. So you can sort of advise your client sort of potential ranges of acceptable commission. So, for example, if 0.5 to 2% of your estate, and look, usually in, let's call them your stock standard estates, where we're not dealing with complex investments or multi-million-dollar share portfolios, perhaps some properties, cash in the bank, etc. 0.5% to 2.5%, if your figure is a sort of between, I don't know, 15,000 and 25,000, you could say to your client, look, this is the range. Why don't we say to the beneficiaries or make an offer at 20,000, provide them with the advice, etc. Let them get some advice. And then that way you don't need to actually make the application to the court. But at the end of the day, if it's agreed upon, then that's usually fine. The court will endorse that, particularly, if the beneficiaries have considered the matter, they've consented, usually the court will be okay with what's agreed.
So just the beneficiaries have to decide and agree on it, basically. So that could also be put in the will that there's a certain amount that person can be covered, because I notice you can put it in, you want that covered, or you want a certain amount of money covered for the wake,
Yeah. So and quite often you'll, if it's likely that the person will charge commission, and perhaps they've also been left a monetary gift or or a gift in the will, there's usually a clause saying, this gift, isn't in lieu of executor's commission. They can still claim executor's commission. So yeah, it is appropriate to deal with commission in the will. And Ella's just popped in the chat that one of her directors has been the executor for multiple estates and has never charged commission. And look, that's out of good faith. And that is an approach that most solicitors or accountants will take, because usually if the solicitor is acting in that role, they will charge their professional fees for doing so. So executor's commission as well, remember, it's to compensate you for your pains and troubles. So you need to be somewhat reasonable. If you've just engaged a solicitor to do all the work, it might be difficult to say that you deserve perhaps the top end of the range if you haven't actually had too many pains and troubles.
There was one case in this week's readings, which was about a guy whose son died and he had to travel up to North Queensland, and he had like all these different multiple assets. He was only a young bloke, but he had lots of things, and they did give him a reasonable size commission for all of his troubles, because it was so full on to time consuming.
Yeah. Yes, time really is a big factor. Yeah, particularly if the executor does have, you know, a normal day job, and they're having to take additional time to attend to these duties. Yeah, absolutely. Excellent. All right, so we're coming up nearly bang on 7. Any other questions? Sorry, we've sort of rushed through commission, but there are some cases in the, I think, the reference or recommended readings that go through that in a bit more detail. So again, have a look through those. They're quite a good example of applying the law and what the court will consider. But any other questions before we wrap up?
I'm going to say the one about
Yep.
the Executive Commission with Section 68 was the Michael Paul McLaren, in the will of Michael Paul McLaren, if anyone wanted to read it. And the one about the guy that lived in the house for 7 years was the Door and Cans, 22022. They were a really good read.
Awesome. All right, I'll take silence as no further questions. Cool. All right, guys. Well, thank you for coming today. And if you do think of anything, do reach out. But otherwise, enjoy the rest of your weeks, and I'll see you next week. Thank you.
Thanks very much.
See
See ya.
ya.
Bye-bye.